But you've also got an attorney that's got to do his job. Your behavior, if true, is making it infinitely more difficult for him to do that.
I want the truth. You can't handle the truth.
Calls case people versus Deshaun Glover.
Good morning, Your Honor, and your staff. Attorney Quentin Dox. My P number is 79657. On behalf of my client, Deshaun Glover.
Your name, sir?
Deshaun Glover.
Thank you. All right, what are we doing?
Your Honor, we're going to ask for a preliminary exam at the earliest convenience.
I don't think that that's appropriate at this time. Defense counsel asked me this morning to get media discovery because he only has paper. I informed him of the proper procedure on how to get discovery from our office, but he is not in receipt of that yet. So I don't think it's appropriate to set today.
So all discovery is not complete.
I have the paper, Your Honor. The digital, I do not have.
You do not have the, okay. Have you requested it as of yet or not? That was just a discussion this morning.
Yeah, I did, Your Honor. I did request it to Ms. Pouzon. She informed me.
Okay, how fast is that going to go out then?
My understanding is that usually it's the same day.
Same day. Okay, so if he does it today, here's what I'm going to do. I'm not going to set the preliminary examination because discovery is not. Go ahead, sir. What do you want to tell me?
So I just wanted to say I've been in jail for 60 days because we've been trying to receive a discovery. And it's like the more you're journeying and push it.
What do you mean you've been trying to receive it?
Mr. Glover, hold on for a second. Just let the judge do his process first, then we can talk.
What I was going to do is I was just going to adjourn it out 1 week so that all of the information is there. I don't know what.
Your Honor, before we set a date, I do think potentially I should address a bond issue first.
Okay. All right. So I'm going to adjourn it, but I'll let you go ahead. What do you want to tell me?
Your Honor, the defendant has called the victim over 300 times. At this point, he has made comments and had conversations with the victim, including things like instructing her to come to court and not let anybody but the defense attorney know that she's there. And he said, they don't have a good phone number for you for nothing, so you don't even need to bring a phone. Just be there in the crowd of the courtroom and let my lawyer know you're there. This lines up with the fact that Mr. Dox has informed me that the victim was going to be present in order to address the court to say that the allegations are false. At this point, I am very concerned about the nature of these calls. Given that there's 300, I haven't had a chance, over 300, I had a chance to listen to them all. My interns haven't, but there seems to be serious grounds for forfeiture here. So I think in order to ensure that Mr. Glover has due process, as well as that we're proceeding in allow us to do our due diligence, we need a bit more time.
Okay, and so outside of the other discovery, that information is also going to be provided to defense counsel, the phone calls.
And that is not going to be able to be sent today because it's my understanding he's used over 8 other inmate pins to make these calls. So it's not a matter of me just sending one email to Ms. Doherty at the jail to have them all released. I have to go in and download them each individually and then manually send them over to Mr. Dox.
All right. Counsel, you have anything to say regarding that?
Your Honor, I believe that the complaining witness in this case, as I alluded 2 weeks before, has been trying to call my client, Your Honor. She is there not to, on her own volition, Your Honor, just to say to the court, not to talk about the case, but that she is not afraid of my client, Your Honor, that she has not been threatened by my client, and that she would like the no contact order to be released. That is to my understanding. And she is in the courtroom right now.
I think that's my conclusion too.
You think she's here now?
Yes, Your Honor.
There, Kaylee Loveday? Okay. So normally, and ma'am, is it correct that you're coming down to ask me to lift the no contact? All right. So here's the way I'm going to handle it, because normally what I would do is I would hear from her, be assured myself that it would be proper to do so. The problem now that I have in this case is that the people have indicated these 300 calls in which the defendant is not to be having contact with her at all whatsoever. But these 300 calls lead the court and the prosecutor's been frank, she can't get through them all, but it's leading the court to believe that there's some manipulation by the defendant regarding this particular criminal proceeding. And so, ma'am, with all due respect, you may or may not be involved in it. I'm not making a determination at this point in time. I'm not going to hear from you today. I'm not changing any of the bond conditions. I'm not changing the bond conditions regarding contact. I am revoking in its entirety the defendant's phone privileges except for communication to counsel. So he should not be talking to anybody from the jail unless it is his attorney. And I've signed that order already. So I'm changing that. The other issue that comes up is she's here today, but I don't know what was said. And by the time we get to preliminary examination, if she's not here, the people rightfully could then proceed by forfeiture. They could also do so, and there may be issues regarding any testimony that she might give if it is inconsistent with other testimony. I'm not going to go through all of that. I will just say this. Sarah, I appreciate what you're saying in terms of it discovery, but it seems to me some of the discovery you're creating yourself, and that has to get over to counsel. So that delay is you.
Yes, sir.
So here's what I'm going to do. So that,
or no?
Yeah, I'll let you talk to me.
No, Mr. Glover.
You're probably
No,
talking
Mr. Glover.
too much.
Yeah, no, Mr. Glover. Go ahead, Your Honor.
All right. So probable cause conference, I will. So that the one part of the discovery is going to get to counsel probably today. How long, and I'm not going to hold you to the exact thing, but how long will it take to get the phone calls to him, you think?
I will do my best to get it to him in 2 weeks. I don't think that I'm not going to be able to listen to them in 2 weeks' time. I can say that for certain. I'm not sure that I need to listen to them all, but I think assuredly I can get them to him in 2 weeks.
Got it. Okay. So given all of that, then I'm going to set, how's that, 2 weeks? Yeah.
Your Honor, can I?
Counsel, would you?
No, Mr. Glover.
Yeah.
One more time. You'll have a chance.
I just don't want to go to court. I just don't want to be pushed back so far. I'm trying to.
You know what? I don't want it to either.
Yes, sir.
But you've also got an attorney that's got to do his job. Your behavior, if true, is making it infinitely more difficult for him to do that.
Yes, sir.
If you stop doing what you're doing, there is not a doubt in my mind that your attorney would be ready to go.
Yes, sir.
So don't be complaining that you don't want anything pushed back. Don't be complaining about any of that. Stop doing what you're doing. Counsel, if those come out in 2 weeks, so just so that they at least get to you and you can look at them, and then we can certainly go from there. Then the next date I have for a probable cause conference after that is the 26th. Are you available?
Yes, Your Honor.
The day after Christmas? Would you be able to do that, sir?
Yes, sir. I'll be via Zoom, but I'll be out of town, but I can do it. Yes.
Okay. Now, adjourn the probable cause conference to December 26, 2024, 9 a.m. Defendant's bond will continue. The changes, all of his phone privileges are revoked. Thank you.
Your Honor. Thank you.
This case shows us that decisions that are made by some judges really do confuse me.
How are you? Shh. So, I have you out here because I have a couple things that have been brought to my attention that are quite concerning. I'm not asking you to say anything. I don't want you to say anything, but I want to put something on your radar. I want to do everything in my power to protect my city, my public, and I'm going to do it in every way that I can. I always give everyone the benefit of the doubt. But from what I understand, state is telling me that you have been allegedly making phone calls or threatening the complaining witness in this case. You're charged with terroristic threat, and I want you to understand that it's a no, don't. I'm not asking much from you. All I'm asking you to do is don't contact this witness. Don't use anyone else to contact this witness. Don't make any threats. I had someone in this very situation not too long ago. I found that they continued to make threats, and I put them in ag seg. I put them in segregation, separation. They literally sit in one room for 23 hours a day, 7 days a week, and they get 1 hour to go out. I don't want to have to do this to you, but if I find that you're threatening the witness in this case, I'm going to have to take drastic measure. And that includes putting you in ag seg. That means they take you out of Gen Pop, put you in this thing, and you're stuck there indefinitely until, I guess, either the case is resolved one way or the other. I also understand that your father is also allegedly as well. He's on bond for murder from what I hear. And if they go up there and they start hooting and hollering up there with the felony judge, it's very possible that they take action as well. Just don't. Life is way too short to spend the next years inside a 6x9 box. It's not worth it. Do you understand?
Yes, sir.
Do you have any questions?
Yes, sir.
Don't make any phone calls. Don't use anyone else. All I'm asking you to do is just don't. You know, if they, from this day forth, if I find that it happens, I will have a hearing to hold you in ag seg.
What I think is BS is that this loser has already undertaken that action of threatening the victim, and the judge is not punishing him from doing that crime. Instead, he gives him a warning. I wonder how it makes the victim feel. And it also sets a bad precedent that now you can be in an orange suit and you're allowed to threaten a victim and get a get out of jail free card. Just don't do it twice.
You have to understand every phone call that is made, any correspondence that is sent, it's all recorded for the entire world to see. There are eyes and ears everywhere. Do you understand?
Yes, sir.
Okay. Did you want to add anything?
Yes, Judge. So I've been in contact with the complainant. She has told me that in the past, she has gone to the hospital because of him because he's been physically abusive to her. She thought that he was capable of acting on his threat had the police not arrived when they did. The first time I made contact with her, she told me that she had wanted the case to be dropped. And then the next day she called me again and said that the defendant, the witness on the case, who is the defendant's friend, basically ensured that that's what she had told me, that she had wanted the case dropped. And so they have been making contact with her, Judge, the defendant, the friend, and the defendant's father. The complainant is in fear for her life. She feels like she's being harassed and threatened. He has been in communication with her since being in jail. She has blocked the jail calls now. I advised her to file police reports so that we can get all this on paper because, for defense, defense has certain rights as well, Judge. And so, we want to do this formally. I would ask that given the egregiousness of all this and due to the genuine safety concerns that the complainant has, I would ask the defendant not be released from custody.
So from what I see now, and I'm going to hear you respond, please.
If I will, Your Honor, right now, he's still currently on bond in this case. And at this point, we have been given no notice of what the actual allegations are. We haven't seen a bond revocation report. We have yet to see any evidence of this other than hearsay from a party that has yet to come to testify to give her own testimony. I believe right now a revocation of bond is improper.
He's right. I know that you're standing up for the complaining witness in this case. I understand. But I have to see, right?
Sure.
And number one, has there been a no contact that's been entered in this case anyways?
There were bond conditions. In the bond conditions, he was supposed to have no contact.
Okay.
But we need a MOA, Judge. There's no MOA in place.
I will grant the order for protection now.
And I've spoken to my client. We're in agreement to that.
So
That's fine.
just, you're on notice.
Wow, he's on notice. I bet this loser is scared about that.
Eyes, ears everywhere. This is what we do. I don't want to have to do anything to you. I don't want to have to put you in seg. So please just don't. And just like I said, life is not worth spending the next couple of years in a box. So you're on bond in this case. I'm not going to revoke your bond now because they've not shown me anything that you have violated other than words. Okay. If they show me something, that's different. I'm going to enter in this order for protection now that prohibits you from having contact with her. So don't use anyone else. You understand, Mr. McCollum?
Yes, sir.
So this order for protection now,
It was signed on 11/7.
I know I'm granting a new one so that it extends it for another 61 days. So that Ms. DeVoe is now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Understand, if you continue, it's very possible they file stalking charges on you as well, right? There's a multitude of other charges that can be facing if it continues. You cannot communicate with this person indirectly or in an indirect manner. You cannot use another person to try to communicate with this person. You cannot be in possession of a weapon, go within 200 feet of where she lives or where she works. Just don't communicate. Are we good?
Yes, sir.
Do you have any questions?
Yes, sir.
All right. I'm going to have you sign this order for protection.
I have a question, Judge, before we, is there a way to attach the father to it as well so that he doesn't have contact or no? I didn't think there was, I just wanted.
So what I had advised and the appropriate way would be go to the felony court,
Yes.
apprise them of what is going on. They can take the measures if they deem appropriate, how to do that. But you need more than just the words, right?
So we should have the jail calls soon, according to my investigator. I spoke to her about it yesterday. Did you want to set it?
So
And
I would like to, at the minimum though, given the benefit of the doubt,
He's giving the person that attacked another person, most likely violently, and he's giving him the benefit of the doubt that he didn't threaten the victim instead of holding him for a couple of hours and waiting on the evidence come back and then locking him up. Instead, he's going to let him out and allow the chance of him going straight to the victim and attacking him for telling the cops about what he did. I wouldn't give him this chance. I think the smarter thing to do would be to wait those couple of hours and get that evidence and remove all doubt.
because I've not spoken to him to let him know the consequence of trying to communicate with her. You're on notice now. They want me to put you in separation now. I'm not going to do it. But if after today, December 4th, 2024, if I find that it continues.
Order in the court.
Okay? I'm giving you the benefit of the doubt now, but it's not going to happen again.
Thank you, Your Honor.
We good?
Thank you, Your Honor.
Life's not worth a 6x9 box. There's so many other fish in the sea. This is not your problem. You're on probation. That's what's holding you. You know what I mean? Come on, man. Really?
I understand that.
Okay.
If you are new to my channel, please subscribe as I edit these cases and remove all of the mundane, boring, repetitive stuff. And I even remove the silences, so you get only the juicy bits, which I think are always the best bits. Are looking for another episode that has all the boring stuff cut out and gives you just the good stuff, then here a couple that may interest you. Enjoy.